Prosecutors in Hennepin County are being asked to enact a very controversial policy. They will be required to consider race when offering plea deals. It's part of a new policy from Hennepin County Attorney Moriarty.
Hello, ladies and gentlemen. I hope you're all having a great and wonderful day. Well, what we have here is a case of racism and a case of violating constitutional law and another leftist prosecutor or leftist person that is defying all laws that we have within this country. It's funny because usually what we end up finding out is that a lot of these leftists are the most racist people, and that's not ending here. What we have here is Moriarty, where she was elected as a Minneapolis prosecutor after the George Floyd incident. Yeah, that's right. So she won the election after the George Floyd incident, and this is what we're coming up with now, that she wants to start ignoring racial laws and stuff like that and just start prosecuting people. Like, you should start basing people off of laws. This is what happens when you hire people based off of, DEI and leftist propaganda and stuff like that, because you get somebody like this.
Julie, this new policy was sent to me by sources within the Hennepin County Attorney's Office concerned that the policy could be unconstitutional if they start taking race-based government actions in their roles as prosecutors.
This is a new negotiation policy set to go into effect Monday in Hennepin County Attorney Moriarty's office. In it, Moriarty lays out several considerations, including race, that her prosecutors should take when extending plea deal offers to defendants. The policy says proposed resolutions should consider the person charged as a whole person, including their racial identity and age. While those factors should not be controlling, they should be part of the overall analysis. Prosecutors should be identifying and addressing racial disparities at decision points as appropriate.
Yeah, so there you have it. I mean, so what you see here is obviously her trying to propose resolutions to charge people as a whole person or whatever by their racial identity and age, which is completely insane, which is completely unconstitutional, and it makes no sense because we all know in this country, as of current, black people commit most of the crime. So what are you going to do when you have black people commit most of these crimes, and you're going to be start doing by racial identity? Well, there's a huge amount of problems here, and we're going to go over it. But another problem that we have here is that it's not just due to being white or black, which is not only the case here. It's mostly going to be protecting black people and making these people not get as big sentences and reducing their sentences, because this is a person here that has quite obviously done this, where she's reduced sentences for other people, for other race, ethnic groups, and I wouldn't be surprised if she did this here. Well, the lawyers here are gonna go over exactly on how this is unconstitutional, how this is not a good idea, and they're not as insane as you think they are.
University of St. Thomas law professor Rachel Moran, former prosecutor Imran Ali, and U of M constitutional law professor Jill Hasday. Ali says he understands confusion expressed privately among prosecutors about whether it means race should be considered when proposing a prison sentence.
Our law, our sentencing guidelines that we have, that the criminal justice professionals use every single day in court, says that race should not be used in that calculus. This seems to contradict our sentencing guidelines.
So yes, this lawyer here pretty much just says, yeah, this is just unconstitutional. I don't see how we can even get through this. Like, this is not something that we can do. And we have another woman here that kind of skirts the way to, like, saying how it cannot be constitutional, but rather we should just avoid this situation entirely because, obviously it's quite bad, which makes a lot of sense. Yeah, it isn't something that at least two of these lawyers really agree on.
Moran believes the policy was carefully written to avoid the Equal Protection Clause of the U.S. Constitution.
I definitely think that some people will get worked up about the issue, but I don't see a constitutional problem. And that's specifically because the policy tells prosecutors to avoid racial disparities, not to create them.
And then you have another one here, the last and final lawyer, pretty much saying, oh, well, it's contradictory. Like, what are we doing here? Like, it doesn't say that you're supposed to be doing this, and it just doesn't fester, right? So, again, where is this prosecutor, Moriarty, everything going to think of doing this when you have 3 prosecutors against this whole deal in the first place?
Hasday reads the policy as contradictory.
It both says don't take race into account, presumably because of the constitutional problems with taking race into account in addition to potentially political objections. But it simultaneously says this is something you should consider.
And because of that, Hasday believes the policy could face constitutional issues, even if it was intentionally written to try to avoid them.
Problem for the drafters of this policy is once you take race into account, it doesn't really matter what else you say. The policy is gonna be struck down.
So yeah, that's what we have here. It's like and this policy should be 100% gone, eliminated, destroyed, struck down, gone. It should not exist because again, we're trying to prosecute and analyze people of their race rather than anything else. And the problem that we have with another problem that we have here with this is that it is a problem. Like if you go and ask Rock and you say, can you consider race in the plea agreements and is it constitutional? You end up finding out that it's not. It says race cannot be a factor in plea agreements under U.S. law. The Equal Protection Clause of the 14th Amendment prohibits racial discrimination in criminal justice processes, including plea bargaining. Courts have consistently ruled that using race as a basis for prosecutorial decisions violates constitutional guarantees of equal protection. For example, the United States v. Armstrong. The Supreme Court emphasized that prosecutorial discretion must be free from racial bias, and defendants can challenge plea practices if they show discriminatory intent or effect. Any plea agreement explicitly considering race would likely be deemed unconstitutional and subject to challenge. Prosecutors must base decisions on factors like evidence, offense severity, and criminal history, not race. However, disparities in outcome persist, often due to systematic issues like socioeconomic factors or implicit bias, which courts have been less likely to find unconstitutional absent clear evidence of intentional discrimination. So yes, obviously it's going to be hard to just do that type of thing, but you shouldn't be going off of race. It's wildly unconstitutional, so she shouldn't be doing this. And again, this woman here, the Mary Moriarty, look at this. She's obviously Black Defenders Matter. She's a huge component of Black Lives Matter. Even if you've been watching my channel for a certain period of time, you would end up finding out that obviously this woman is just bad because she's going to be choosing Black people over whites in most scenarios and bringing them easy deals and what have you. And then what ends up happening is when you see all these Black people committing these crimes over and over again, it's going to give Black people a bad look because it's like, okay, only Black people are committing this. When it's just these same Black people are being released out into the streets because they committed these crimes, and the prosecutor, Mary Moriarty, refused to prosecute them. And then add insult to injury here. She was also, the Hennepin public defender, she was ousted. Nobody wanted this woman to be here. She was voted out of the post Wednesday because she was so woke, nobody wanted her. So that's the insane part. And then if we add this here too, for reasons why this woman is a bad selection, it's not just because she's far left or what have you, which is a big factor. There's actual evidence here showing that she released a person after did a massive killing of white people or whatever, and just didn't prosecute. This is what we have here.
A defendant by the name of Hussein Braveheart. He is now 20 years old. In 2019, Braveheart was just shy of his 16th birthday when he was involved in the deadly carjacking with a teen co-defendant by the name of Jared Osman in Northeast Minneapolis. The pair admitted they were attempting to rob Stephen Markey and steal his car. While both young men fired, it was Osman's bullet that killed the 39-year-old. Osman subsequently pleaded guilty to second-degree murder in adult court and was sentenced to nearly 22 years in prison.
So again, this woman here, Mary Moriarty, is pretty much saying that he has completed 2 residential treatments and he's done everything that's required of him, and sending him to a correctional facility will just cause more trauma, more issues for him. And I'm like, I don't care. Don't put him out into the streets. This guy is obviously dangerous, and she just doesn't care.
He has successfully completed 2 residential treatment programs. He's made significant progress, very significant progress. And so sending him to prison, based on everything we know, will create more trauma and make him likely to be more dangerous when he gets out.
So yes, this guy has a massive amount of criminal history. And if we want to just break it down into the TLDR, it's just that the family was shocked when he was brought down from a second-degree murder charge to, well, not second degree, but just murder charge in general, all the way down to just assault. And this is what this woman says. And everybody in the county was shocked by this.
Yeah, this is the same suspect, by the way, that put Hennepin County Attorney Mary Moriarty under a microscope after she agreed to a controversial plea deal that kept that teenager out of prison. This morning, though, Hussein Braveheart remains in custody. He'll be facing new charges for 2 armed robberies that happened just days before the deadly carjacking back in 2019. Braveheart was one of 2 teens arrested for killing Steve Markey during a botched robbery, but the family of the victim was stunned when prosecutors offered to drop the charge of second-degree murder down to simple attempted assault.
Yeah, so obviously you see here, this woman cannot be trusted. She cannot be a person that would be just for the law on just this basis alone. And now we have this woman, because this person is of another ethnicity, of another race, she is just going to go out and put these people out free from jail or lower their crimes just based on race. She's being racist. She's using racist discrimination. She's breaking the constitutional law. And if anything, if Kash Patel or any of the Trump administration gets wind of her, she should be imprisoned for a huge amount of time, because that is insanity here. She is endangering her public community and everything else regard. And yeah, it is not good. But what we have here is a simple matter of insanity coming here. And of course, we have more with this case, with the woman here causing these issues.
Mary Moriarty declined an on-camera interview and didn't answer specific questions that I had regarding potential constitutional issues. In a statement, a spokesperson wrote, in part, this policy acknowledges that there are many factors to be considered in negotiations. A defendant's race matters because we know unaddressed, unconscious biases lead to racial disparities, which is an unacceptable outcome.
So again, what we have here is that this is a policy directly from the Hennepin County Attorney's Office, which is the prosecutor, which is Mary Moriarty, is the one that is saying this. And I have a problem that these people might be in trouble, like the prosecutors that are coming up with this and spreading this out is probably going to be in trouble just because of the mere fact that this just can't be allowed in her eyes. And so they'll probably be fired for this. Hopefully not, because that'd be insane. But the thing is that the unconscious bias thing, this is the crazy thing here. What it's saying here is that if you see a black person or anybody of another race going into being a murderer, and then you're thinking that, oh, well, that person should probably be put in jail, and you happen to be a white person because that person is black, whatever. That's insanity to me. That is absolutely insanity. That makes no bloody sense. But the problem with this is that Mary Moriarty does the same thing. She thinks this way. She thinks if you see a black person or anybody other of an ethnic group and you're white and you think, oh, they committed a horrible, terrible crime, they should be locked up in prison. She thinks that you have unconscious bias and this is your fault. This, of course, everybody knows that's insanity here, right? That's completely insane, but that's what she thinks. And that's the insanity part. And then, of course, we have these 2 reporters here trying to digest, trying to figure out on how what she can actually mean here. But for any rational human being, we can't figure this out, because if you're not a racist, you don't think like this.
It is hard to look at that, though, and not think, how can that be constitutional?
Right. Well, what Jill Hasday says, the constitutional law professor, she specifies that when it comes to age, Moriarty in the policy addresses reasons why age is to be considered, and that has to do with the science behind the brain development, stuff like that. So Hasday thought that it was adequately explained for age to be constitutional, but she says the U.S. Supreme Court is so much stricter when it comes to race, and their past rulings made it clear that you can't cure societal problems with racial disparities by using race in government actions. That's the explanation from the constitutional law professor.
And the thought is that someone who is a white person, for example, will be the person to bring this case forward, and it could go, who knows, all the way to the Supreme Court.
Defense attorneys would call and say, look at this, I didn't get as good of a deal for my client as this person is getting. That's the fear that it would raise.
Yeah, so again, these reporters are trying to figure it out and try to think of how this would possibly be a thing. And again, it's just based off the age or the what have you, but that's insane because she's already tried to do something like this to where the age is you can't prosecute people as hard until the age of 26 because your brain's not fully developed. Obviously, your brain's not fully developed until 25, but your actual reason of wanting to hurt people doesn't matter. Like that, the fact of it is, you know right from wrong at a very young age, mostly. So the fact of the matter is that it's insane that we want to reduce crimes for people below the age of at the age of 26. It's insane. It makes no sense. We have deemed 18 as the age as adulthood for kids, even though that's kind of weird because adulthood, becoming 18 doesn't mean you're doing adult things, right? But that's neither here nor there. We have deemed this at the age of 18, and if you are doing things that are like harming people, murdering people, offing people, what have you, you should be charged for the crime that you committed because you're an adult. And even still, kids shouldn't even be charged for crimes as an adult if they're severe enough. So the point being is, it's insane on how she's doing this, and that makes no sense. So yeah, this is what we have here in Hennepin County, how Minnesota is just completely just gone, and I don't understand how we're here at all. All right, guys, that's it for the video. Like, subscribe, share. As always, take care, my friends.